We began our case study method in 2021. Myself and my teammates had an open session with Phil every Wednesday or Thursday at 3 p.m. to problem solve our cases together, discuss what troubled or excited us in the legal industry, and most importantly, to hear Phil's advice, feedback, and most often, his inspired creative solutions. In this podcast, we can't talk about my life cases because if we do, I will not have a career tomorrow. But we can still share concerns, get excited about problem solving together. We can still bring a potluck of ideas to have a buffet of different perspectives to understand our world and each other better. My name is Donna. I'm a lawyer by trade, but for today, I'm just your case finder. Welcome back. Feels like the good old days, just with more lighting and better cameras.
I think of deja vu.
This deja vu. Those 3 p.m. every Wednesday and those open sessions. But thank you. Just want to say thank you, for all those open sessions, which we're now expanding a little bit more to a little bit to wider audience. And talking about hypothetical cases and what's happening now, I've watched this show on Netflix, Adolescence. It's a Netflix series which drew the public's attention to the process of juvenile prosecution of this character, 13-year-old Jamie. And this he's facing the young people of today and the adults surrounding them. I think I know the answer now, but I'm still going to ask you live. Have you watched it?
No, I haven't watched it.
No, it's all right. It's fine. You don't need to watch the Adolescence to get value out of this podcast because, firstly, there is this helpful article. Before we start, I'm gonna rabbit on a little bit. It was published in Lawher, which is a candid review of Jamie's solicitor, fictional solicitor, Mr. Barlow, in that series. The article gave us a candid feedback from a solicitor's perspective of how Mr. Barlow may have fallen below what was expected of him as a defense lawyer. It was written by Rebecca Smart, and the title is Adolescence is Brilliant TV, but Jamie should have sacked his brief. And then she cited, just now, if you could indulge me a little bit, she cited 5 reasons. We will post the link. She cited a breach of confidentiality. She cited that Mr. Barlow told Jamie he did not need to give the police his phone password, but in fact, if the police had a RIPA warrant, which is Regulation of Investigatory Powers Act, it would be a criminal offence to refuse giving up those passwords. Jamie also did not need to give a blood sample, as it is an intimate sample under the Criminal Evidence Act 1984. Mr. Barlow failed to tell Jamie this. Fourthly, Mr. Barlow failed to achieve key objectives for a lawyer defending someone at a police station, as described in Defending Clients at the Police Station, according to that article. And finally, and this is quite interesting, I will ask you about this, Phil. According to the article, the advice to give a mixed, no comment interview, Ms. Smart noted this as inappropriate in any circumstance. Phil, juvenile cases. Have you done any juvenile case in your career?
Over the years, yes. Yeah. Over the years, I have done. And
what are your thoughts about it? What's your general recollection about doing those types of cases?
Well, on the last thing you said, first of all, I respectfully agree with the person who made the comment that it's always a mistake to give partial answers. Yes. I think it's entirely wrong. Either you answer the questions or you don't.
Right.
I mean, it's you're perfectly entitled not to, but as the police officer interviewing will often say, it's suspicious if you don't. Frankly, I agree. It does sound suspicious if you don't. If you answer some questions and say, I don't wish to answer whatever in relation to the others, and that's not a good idea. That's irrespective of whether somebody is juvenile or an adult. I have dealt with various juvenile cases over the years, and They're a mixed bag, really. I mean, juveniles are very difficult to defend, in my view. They are very well protected by the law generally. So, for example, if a juvenile finds themselves in custody, then the police need to get hold of a responsible adult or a social worker so that they're accompanied at all times. And the extent to which they are protected was brought home to me by a television program I watched about an American case, which was the making of a murderer. And we won't go into that, but there was a juvenile who was related to the alleged murderer, and he was questioned by police officers on his own for hours. And so that was in complete contrast, really, to the situation in this country.
Yeah.
Where if anything, there are an enormous number of protections. There was an individual that I represented who's remained nameless. I was a duty solicitor and called out, and I had to know the lad who was at the police station, and there was a time when he was regarded as being responsible for a good many burglaries in the St Albans area.
Right.
And the thought was that he was fully aware that actually he couldn't, and because he was too young, he couldn't get a custodial sentence. And so, in a sense, he was given a sort of a blank check to commit offences. Now, I don't know if that's right or not. I wouldn't suggest one way or the other, but certainly that was an element. So the question of what you can do or what can happen to a juvenile is of some consequence.
How old was that?
How old? I can't remember now. So many years ago. But it's quite interesting in general terms. I think when you look at children, the idea, I think one could reasonably say that there weren't teenagers until after the Second World War.
Right.
Well, the reason for that was everybody had to go to work.
Yeah.
You left school at 14.
Yes.
If you were working a week, then you had to give your wage packet, because people were paid wages in a packet in those days, to your parents and were given 2 and 6pence pocket money for the week. Then teenagers, as we know them, didn't exist. And of course, then the powers that be extended the school age requirement. So it went from, I think it was 14 to 50. And it's since gone further. So that you are almost creating an artificial class or group of individuals who are almost adults, sometimes look like physically adults and perhaps mentally are, but they are still school children. And so I think that throws up all sorts of difficulties from society's point of view.
What's your, if you could reflect on, the 50 years of your experience, what are the remarkable changes in terms of the pattern of offences early on in your career, of juvenile cases early on in your career, compared to the latter part, just before retirement or towards the latter end of your practice as a criminal defence lawyer?
Yes.
If there are any, or any patterns or maybe there's no change, I suspect there is.
Yeah, I think only in the broadest terms. So, for example, initially there were approved schools and boarding schools. And my impression is that juveniles were treated much more severely then than they came to be treated. So that, for example, by the time I finished that sort of work, the parents of an adolescent could be taken to court for failing to control it. So, who's responsible? It's no longer the person who's done whatever it is that's complained of, but somehow or other the parents are. So there's a sort of a shift, I think, in societal thinking away from the perpetrator to the background, including, of course, the parents in the example I've given you. So that's the change I record. I mean, I didn't like dealing with any kind of child case by the end of my career, whether it's adoption or custody when that existed, or juvenile, because it seemed to me to be a situation where it was more an arena for probation officers and social workers than it was for a lawyer. A pure lawyer was almost irrelevant.
Fine. Because, I mean, I'm a private children law specialist, and we always say that the law in that area is not simple, but straightforward in some ways. What is in the best interest of the child? And
One
that's
sentence, that's it. That's
one sentence. Yeah, that's it. Yeah, we often talked.
That's the end of it.
We often talked about it.
And that ad lib.
Yeah, and
Yeah.
and we have all this multi-agency approach to dealing with cases, social workers, CAFCAS, police. And the idea is that hopefully, because you talked about this shift from focusing on the perpetrator to the shift on the focus or the shift of the focus on the parents and the upbringing. Do you think there's a reason why the children family proceedings, or whether private or the care proceedings, are getting quite robust at trying to sort of prevent issues from becoming more serious? I think what I'm trying to say is I often hear this, that they don't want these young children to turn out into problematic adults themselves.
Well, I mean, we're talking in those general terms. I should think that in some of those cases, it's more or less self-fulfilling. There'll be a continuation.
Can't be stopped.
Yeah,
Can't be intervened and can't be stopped.
It's essentially, I think that's entirely right. But,
Yeah.
But my own antediluvian comment about this is that, seen, I hope objectively, I think that really, if society wants to achieve the object of them being responsible and self-disciplined children who become adults, then I think what they should actually do is reinforce the family. So that doesn't necessarily mean reinforce marriage, but it does mean reinforce whatever the union is. You have a whole range of unions. You have a civil partnership, don't you, these days, as well as marriage. That could be extended so that many people who cohabit now could enter a civil partnership if they chose not to be married. And that could be encouraged by, for example, very strong tax advantages. Because if you have a secure family, then it seems to me that there is far more chance of your having secure and reasonable offspring who become reasonable adults. So it would also deal with, I mean, there is no cohabitation law, frankly, at the moment, is there?
Correct.
There's constructive trust, and if it's not that, then you've got nothing.
Yeah, correct.
Right. So you would sweep up the whole thing, really. You could recognise the social practice of people not formally marrying by having a civil partnership which encompassed whatever the arrangement was. And you could reinforce that quite straightforwardly, but most importantly, by things like very considerable tax advantages. And you would probably also reinforce the family. You see, just take one example. After the Boer War in 1900, the quality of men who presented themselves for service was so poor that Baden-Powell, who was a soldier, started the Boy Scouts.
Right.
And one of the principal objects of that was to improve the quality of the nation's potential soldiers by producing self-disciplined young men. Now, that's a long time ago, and a lot of people might think that's still very strange, but I only use it to illustrate the point that if you want to achieve the end which we've discussed, then the law's neither in or there, and what you do to them is almost academic. You're always going to have the problem unless you go to the root of it.
Understood.
And create the sort of situation, in my opinion, I just described. If you do that, then there's far less likelihood that you're going to need the other stuff anyway.
Right. So go back and have this optimal environment.
Yes. What is fundamentally the best thing for bringing up children? In my opinion, it's a family.
Yes.
Of whatever nature, and there's a tendency, really. I wouldn't mind betting that if people were to look at a lot of these cases, you're looking at situations where there are single-parent families.
Yes.
And whilst anybody who commits an offence is not necessarily going to come from a single-parent family, I wouldn't mind betting there's a much better chance.
Mhm.
Oh, there you are. That's my antediluvian comment.
What? But how about the role of social media, Phil, and technology in the pattern of offences being committed by the younger people in the last 20 years? What do you think has been the impact of that?
I think that social media has had an impact in many ways on the lives of all people of whatever age, quite honestly. I do think that if you have, if you're supporting families, if you're going for a family-based society, then any difficulties of that kind can be dealt with by the family. There will always still be problems because, for every solution there's a problem. But I don't think it's something which is confined to the young.
Yes.
It's just simply a problem that society as a whole has to deal with. But I still think that if you have a society which is anchored, if individuals are anchored properly, that there's a much better chance that they'll be able to cope with whatever life throws at them.
Well understood. And going back to procedure, from your experience, what's the most important thing to remember if you're a solicitor or a duty solicitor or lawyer advising a client in a police interview, if ever it has to come to that?
Advising a client of whatever age.
Of whatever age. I mean,
Yeah.
let's go with juvenile client first,
Yeah.
and then we can expand that to whatever age, because it may be that there's a slightly different approach, and of course.
Oh, I think there is. Yeah.
Yes.
There is. It's,
of course there is, isn't it?
It depends, but when you're dealing with a juvenile, then I think preferably the parent being present.
Yes.
And you letting the parent speak to the child before you take any kind of instructions, we call them. It's absolutely essential that the parent is fully involved, and then you speak to them. And that, I think, frankly, I'd be inclined to advise the parent more than the child, because they're the person, if you like, in legal authority. You're very much an advisor, and what you advise them is going to depend upon all the circumstances, but it's very much to the parent or guardian that I would address my remarks.
And this I'd like to review, because one of the critiques of that show, Miss Smith feels that the solicitor, Mr. Barlow, should have checked with Jamie, that's the child, whether or not the solicitor could talk to the parents about the case and not breach confidentiality in that way, or pass the test of confidentiality versus the consent requirement. What's the duty of care in juvenile cases? How do you balance that? Because clearly you'll have parents who'll be wanting information, be wanting to know what's happening.
I think this is illustrative, really, of the sort of problem that I've been talking about, that I see.
Yeah.
If you approach things in that very legalistic way, it seems to me that you run the danger, really, of reinforcing, if you like, the juvenile's behaviour, which might be very bad behaviour.
Yeah.
This is a criminal matter. You'll be afforded all the
Yeah.
rights of the law. You must not. Well, how is that necessarily helping? We're talking about, this is a stage, really, in people's lives when the framework of the law is such is that they start from the basis that they're going to try and assist the individual. So that to be so legalistic about it, I think, is a problem. I'll give you an example. In Whitechapel once, there was a young man, knew all the responses. Whatever he said to me sounded as if it come straight out of a probation report. So he had become not institutionalized, he had become educated into the things to say.
Yes.
And,
scripted.
That's right.
And obviously rehearsed.
That's right. Being an ardent young lawyer, I was saying to him, well, I stressed that he didn't have to say anything to the police, and that if he was arrested, all he should do at the most really was give his name. And then one day I had a telephone call from a police officer.
Yeah.
I said, look, we've got this chap with us. He's been with us for days, but we've only just got his name out. And it turns out that it says you're his solicitor. We won't say anything else.
And how was that? How's that?
So he had been living nearby in Brick Lane,
Mhm.
which was a much rougher area than it
Yes.
is now. And he'd been arrested because a policeman had seen him climbing up a drain pipe.
Right.
See, so naturally he thought, well, he might be trying to burgle or
Yeah.
house break, depending on the time of day. In those days, there were it depended on the circumstances, what the offence was. So, oh right, okay. So I went down to the police station. It turned out that he had been climbing a drain pipe because he'd forgotten the key to his flat.
Right.
And he was climbing up the pipe to get in. So when the police officer said, "Oh, what are you doing?" and took him to the police station, he wouldn't answer any
3
questions
days.
at all.
Yeah.
None at all. So
they
he
got
spent
was
2
the-
days at the police station, quite innocently.
Quite innocently. When there should have been a perfectly fine
Yeah, that's right.
explanation.
That's my plan. I forgot looking. But so you run this danger
Yes.
of sort of coaching people into a rather artificial situation. It seems to me. So, what's your object? What's your
Yeah.
what do you intend? I think lawyers should only present really in juvenile cases as a kind of a legal point of reference.
Yes.
But after that, it's the other agencies who I think largely dominate the proceedings anyway,
Yes.
who have the sort of the driving seat.
Understood. And to expound that question to the rest of the cases, not just juvenile, so if you are advising an adult client in a police interview,
Yeah.
what would be the focus of your mind at that particular time?
From a purely objective legal standpoint,
Yes.
I often used to feel very guilty about saying this to people, but I mean, the plain fact of the matter is, most people are convicted, in my experience, because of what they say.
Mm.
There are some people who, against whom the police officers have sufficient evidence to convict them anyway, but the majority, simply by admitting that they were in the area, reinforce other evidence that the officers have,
Understood.
and it leads to their conviction. So the only sensible advice that you can give some is name, rank, and number only. Say nothing else. They can only keep you for so long.
Yeah.
But there are very few people, even professional criminals, who I think can keep their mouths shut. As being locked up in a room
Yes.
on your own.
It creates that pressure.
It's a pressure all of its own. And very, very few. I can remember one individual that was capable of doing that, but that's only one that stands out. Most people,
Yes.
if they're professional criminals, you don't come across many of those because they don't normally get caught. But if they're a professional, they know what the rules are. But even they find it difficult not to try and do a deal, or way out of something, or arrange something.
Yes.
So, but basically, if you say absolutely nothing,
yes,
sooner or later the police officer will have to let you go. And then the question is, what other evidence is there? Actual evidence.
So,
and there's likely to be very much less.
And that's because of the burden of proof, isn't it? Because
the burden of proof is such. The burden of proof is such that you stand a much better chance if you say absolutely nothing.
It's the prosecution's job to prove their case.
Sure.
So, in layman's terms, they have to prove 100% without any iota of a doubt. But that's criminal. That's different in civil.
They have a tremendous responsibility. I feel very sorry for police officers who are facing this kind of difficulty. I mean, they may have a very clear view, and they may have evidence which they can't sort of reduce for one evidential reason or not, that this person has been involved in whatever the activity is, and they then have a mountain to climb to try to establish it to a court satisfaction. And if they can't thoroughly question someone, then that makes it much harder for them.
How do you explain to a lay client, a non-legal person, this principle of adverse inference? So, if they, and when are the situations where the court could draw adverse
inferences? How would I explain that? I'd say basically they changed the caution. to include this particular, the court can draw an adverse inference from it. I say, but that doesn't change my opinion. Say nothing. Because if you say nothing, there's no inference they can draw from it. What inference can they draw from the fact you said nothing when you're legally entitled to say nothing? So it doesn't actually affect my advice at all. I'd say my advice would be the same.
Would you say that amongst legal practitioners, that's a fairly common approach?
I honestly don't know. I mean, it's you don't normally have a conversation. I certainly didn't have any conversations with people about that or the advice you might give them. You'd have to ask them, individually. Different people would express and take different views. So that's my opinion.
Understood. What would you say to a person who's about to be interviewed by the police? Advise him rather than advice to his solicitor. How should they approach? I mean, I know that your legal position is it's better to say nothing, but any other pragmatic advice if if the viewers are being invited to talk to her. But this is not legal advice. This is more of a bold conversation about things that concern us, isn't it? Things that excite us in law. I think this is more a philosophical approach to it. What would be, I think, let me change the question. What would be something useful to remember if you're in that situation?
I think it's a question of balance and experience, because there are situations where it's actually in somebody's best interests to answer the questions.
Like your chap.
Yes, exactly.
Like your chap, isn't it? Yeah.
Very good.
That's a very good example.
That's right. But also, if you've committed the offence, say you've stolen something by way of shoplifting, or you've got a small quantity of drugs or something of that nature, then the chances are that if you are open about it and say, well, yes, I'm sorry, I did do it, and I've been under a lot of stress, whatever it happens to be, there's actually a pretty good chance you'll get a caution rather than be prosecuted for an offence. So that
an early plead, as we call it,
is that what they call it? Okay.
Or I don't know these days with. But yeah, we're talking non-legalese anyway, so
that's right.
just up to it and explain the situation.
Explains it. Also, I did do it, and won't do it again, or I've got problems and all the rest of it. So that it's much broader, really. It's like most things in law. The initial response isn't necessarily the right one. So it's like if somebody asks you to witness a second charge. I've signed it. My wife's got to sign it. Will you witness it? Well, yes, you're not just witnessing a signature, though, are you? You have to ask the wife whether she understands the full ramifications of what the money's for, what the overall financial position is. You've got to go much deeper. The same, I think, is potentially true with an individual in custody, so that the strict legal advice of say nothing is correct,
but not necessarily true.
Not necessarily appropriate in every case.
Correct. Yeah, which is the story of our life in law. Each case stand on its own.
I agree entirely. And as in most cases, the amount of information that you are given is minimal.
Yes,
absolutely minimal, and you are expected to provide advice on the back of that, which is a very difficult task.
Yes.
In truth.
Yes. It's the same in civil. I mean, your early meetings with a client, you're not necessarily having the full disclosure. Rarely would you won't have the disclosure from the other side. Very, very rarely will we have the amount of disclosure that we have eventually at the formal disclosure process when you're in civil proceedings compared to what you have at the first or second meeting. There's a great disparity on that. So you are being expected to advise on the basis of that partial view into the landscape. And that's the reason why the advice is, well, we need to know. We need to know what they have. We need to know what you have.
Yeah.
And to be able to finagle those factors or those blind spots in a case, whether civil or criminal. Although it's harder in criminal because obviously, they'll only give you what they want to give you.
Well, that's exactly that point.
And the same in civil in some ways.
Yeah, rather than they're actually prepared to tell you.
Exactly. It's same in some ways. So you're waltzing with that unknown, and you're giving advice to this client who may not be giving you the entire story as well, isn't it, Phil?
Almost invariably not.
Yeah.
It's that's the nature of the activity, really. I think all you can do really is put your best foot forward and such. But I was about to add, and I'll add now, and try to protect yourself in the process.
Yes.
Because, after the dust has settled, then that client is perfectly possible that they will take the view that they now want to have a go at you because you gave them the wrong advice. I mean, an example in criminal work would be where a deal is done with the prosecution and somebody tenders a plea to a lesser offence.
Mm-hmm.
And they're happy to do it at the time, which means they don't get 3 years in prison. And then later on, you blow me, they appealed on the basis that they didn't understand what they were doing.
Yeah.
And their lawyers did X, Y, Z. I mean, barristers used to have the practice of, if they did give people advice, they would write on the brief and get the client to sign it that they had been advised.
Yes.
So I just take that as just one example off the top of my head.
I've done that actually in some cases without breaking confidentiality, and it's just a general comment in situations where it is absolutely important that there's a paper trail, that the advice was given in pure, simple English, nothing jargon, nothing legalese. That I told you that this will likely to happen. We can't guarantee. That's the wording that we use. You probably picked up on it now, likely, most likely, less likely, because there's no guarantee. A lot of this would depend on factors yet to be unraveled, disclosure from the other side, discretion of the judge during that day. That's what we call litigation risk. So we can only really give advice in those terms. But it's very, very important.
You need a lucky rabbit's foot.
Yeah.
I mean, even with judges, even if you've got a paper trail, I've heard this before now. A case where, the simple thing, the judge said to the barrister at one stage in a particular case, well, didn't you get a copy of the indictment from the court administrator? Well, we did write for it. May I see a copy of the letter? Copy of the letter shown to him. Judge looks at it and says, did you send a reminder?
Yeah.
When you get it? So, I mean, you are really onto a loser when it comes to hoping for, or you certainly don't expect it, but hoping for any kind of support from Alfred Wig's brethren.
Yeah.
That will not be forthcoming. And so if you find yourself in a situation, well, then that's a whole new discussion.
It's a whole new discussion, because from a juvenile prosecution to... But yes, a whole new, probably a 2-hour discussion. Do you remember the intro? What excited or troubled us about the legal industry, and a reflection of how we navigate this world. There's this line in Adolescence, Phil. I know you haven't watched it, but this stuck to me. The solicitor said to 13-year-old Jamie, this fictional solicitor, "You do not need to tell me you did it." He said that. Could you explain to the audience the rule? If someone told you, your client told you they did it, what can you do and what can you not do?
Well, I mean, if somebody says that, look, I did it, how do I get out of it? You have to say, well, look, I can't represent you on the basis that you are innocent if you're telling me that in fact you're guilty of the offence. So what we'll have to do is to look at what happens in the event that you acknowledge your guilt. But it's not always as simple as that. I mean, you can have a situation. I had a situation once where I was defending a chap who'd driven his car the wrong way around some traffic lights before turning right. And part of the traffic lights was a police car who just happened to notice that somebody had overtaken him up on the wrong side of the road and sped off.
Yeah.
So the car had tinted windows, so they couldn't see the driver.
Right.
But obviously they saw the index number and they turned up at this chap's house and said, all this happened. Were you the driver of the car? And his answer to that, as recorded by them, was, I might have been. So he was prosecuted and he told me he had done it. So I said, well, look, they've got to prove it, which includes proving that you're the driver. Can they do that? So after they'd given their evidence, I submitted no case to answer because they'd failed to prove that he was the driver. They couldn't rely upon I might have been the driver because he might not.
He might not. And you were fine with carrying on with
up until that point,
because yes,
they found no case to answer. Yeah. And I'd said to him, and he'd accepted that if they found there was a case to answer, he would then immediately change his plea to guilty.
Yeah, understood.
So that you can have a technical situation where you can do what I did, I think,
which is legally enough within the bounds, isn't it?
I believe so. I believe so.
I think that's the right answer. My client would like to think he believes so. I think.
I believe so.
The purpose of
on that occasion it worked, but that's just one example. It depends. That's all. The only two words you need to know to do.
Yeah.
It depends.
It depends. There's a classic answer. It seems. It depends. What's the biggest? I think you touched upon this with your reflection regarding the US drama, The Making of a Murderer, compared to the UK's approach to juvenile cases.
Oh, yeah.
What's your reflection on the general philosophy of the UK legal system relating to juvenile prosecution or juvenile rehabilitation?
Well, it's only an impression. I'm not.
Yeah, it's only an impression. You're not holding yourself out as an expert. Yeah, just an impression. 50 years. So you're retired now. I think that's asterisk retired now, but that's 50 years. That's incredible experience and a good chance to reflect on changes. A good chance to reflect on patterns as well as overall philosophy of this legal system.
Okay, well, I mean, by and large, I personally think it's very fair. Whether that's
a personal view, don't
it's a purely personal view based upon a limited experience in the local courts and some London courts. Whether or not it will be borne out by other solicitors practicing in other places altogether, I honestly couldn't say. But my impression is that juvenile courts that I've appeared in front of have been very reasonable and very fair, and really sort of bend over backwards to try and find out what's going on.
Yeah.
Rather than looking at it from the point of view of punishment.
Understood. Yeah, you mentioned that the multi-agency approach, and suddenly it's going to be taken over by the social workers.
Well, it is. I mean, the rules of evidence don't apply to them. You don't ever want to have to find yourself cross-examining a social worker.
Yeah.
All you get is opinion, which wouldn't be allowed in another court. I mean, you try objecting to a judge and say, look, this is not factual. This is not. You'll get absolutely nowhere. So that I felt was often very uncomfortable in that sort of environment.
Yeah.
Because a lawyer is by definition designed for contentious cases.
Yes. And what would you advise, what career practice advice would you give to a young duty solicitor today? And there's a follow-up to that. Would that advice be different if you are talking to a young duty solicitor? Young duty solicitor is the one who gets called in the night to advise on truth lease interview. Would that change if you were talking to someone in the year 1960s, 1970s, compared to a young duty solicitor in 2025?
Well, things were so different, really. In the 1960s, I mean, the advice, I think, broadly would be the same.
Yeah.
I think it would be broadly the same.
The advice to a young career advice to a young duty solicitor
would be look for another career. Go for Greek deck chair attendant. I think would be appropriate. think of all the sunshine and practice your foreign languages. So be sensible.
It's a hard. It's a hard.
Well, it's a terrible
It's a
arrangement.
hard
I mean,
job.
why they didn't just say, well, look, nobody can be advised before 8 a.m. in the morning, and the police can't actually interview anybody before that time. So the rights of the individual are protected, and you don't have to get out of bed, drive all the way to some flipping police station, and be told, oh, the person's asleep now, they're entitled to rest, you have to go away, which does happen.
Yes.
So, and, you know, it's and then also you would only pay for perhaps half the time. You pay for a day rather than 24 hours. But no, we have to have 24-hour court. And a very good number of those cases are, frankly, a waste of time.
Yeah, and that's the same in 1960s and in 2025.
Absolutely.
Yeah.
It's certainly
That's a
no
good
different.
reflection. Yeah.
Certainly no different. Drink driving was very exciting in those days.
And what?
There was one chap who was pursued by the police. He'd driven his car. It had an accident and it was on 3 wheels. He'd driven it 3 times round a roundabout at Watford. Completely out of his mind. Then he drove up onto the roundabout, leapt from the driver's seat into the back seat, and as the police officers reached the car and surrounded it, he said, "You can't nick me, I'm not driving."
There you are.
So that's a bit more colourful.
It's a bit more colourful before.
Introduced a bit of, enjoy
now
entertainment into life.
Yeah, now it's become a bit more. Well, but it's so boring is not the right term. It's just
less colourful.
Less colourful. Let's use less colourful, and
that's right.
Yeah, there's all the rules and there's all the
housing.
All of that.
Oh no, it's far more. I mean, you need a little bit of entertainment in life.
Yeah, that's true. Well, any final thoughts, Bill? You mentioned already, because we'd like to look at least forward, something hopeful, something that could make things better. And you mentioned the role of the family. Any final thoughts, just in case your local MP is listening and might be minded to legislate?
Family for anybody would be, but I do think that the trouble is that law is often tinkered with in response, almost like a knee-jerk reaction. But if you really want to fundamentally rebalance things, then you do need to take. I think it's fairly straightforward action, really. So the idea of reinforcing the family, better minds than mine can decide how that should be done, but I'll give you an example of what I think you could do. And it would also clear up areas of matrimonial law that we deal with at the moment. How often do you hear about cohabitation in the office and the need for some sort of relief for people in those circumstances?
Yes.
Well, you could sweep up the two together. And I'd also be looking at remedies. How do you enforce whatever judgment is forthcoming from whatever the claim procedure is, which, in my experience, is more or less never.
It's very hard. It is very hard.
Never looked at.
Yeah.
What is the point in reforming procedure, in bringing procedure? It's like building a motorway which ends in a country lane.
Yeah.
It's a complete waste of time. So then you sweep everything away, you replace it with another procedure which fails to achieve its object.
Understood.
So
and that's always been an area that we talked about in the past. That when we say enforcement, so when you win a case, I'm talking civil case here, ultimately the client is really interested in only one thing: can I get my money back?
Well, why did they bring the claim? Well, exactly. What was the point of bringing the claim?
And there are hurdles and procedural, and yes, to a point, to a degree, rightly so, but it is a hard process, because I think one of my part, without breaking confidentiality again, you end up coming back to court with an information hearing, an attachment of earnings, a potential charging order, and each time you come back, that's cost, that's money. And the client's going to be asking, yes, we won, but when am I seeing the money coming the other way around?
It's good money, it's bad. I mean, why not simply take a modern view? I'm not suggesting you send people to prison for debt. Probably there are some individuals out that could reasonably be done to. But why don't you just simply say, give the court power to order that somebody should not be entitled to apply for credit, whether it's a debit card, of any kind, until the debt is clear.
Yeah, that's
because living in our society without the ability to buy things on credit is very difficult.
Yeah.
So simple. That's just an idea, but simple steps like that.
Yes.
So you give them power to order it, and power to disseminate that information in a way where it's acted upon. Or rather than create an agency to pursue.
One singular agency.
With all the attendant bureaucracy and costs and lack of success, rather than simply give the existing courts power to make an order which they can enforce through the Inland Revenue and the National Insurance System.
Yeah.
Something effective.
And efficient.
Yes.
We're not talking about absolutely dismantling this process of giving people a chance to let us know about their means.
Well, the court will inquire into it. That's what their job is. They will inquire.
They will inquire, and that's
make their order.
fine. Yeah, and they can make the order, and
then that's it. Job done. And they then that is then properly communicated and enforced. You'd have a great deal of difficulty in our world avoiding national insurance and the tax authorities, so that and also acting without credit.
Yes.
Very, very difficult indeed. So I suspect that for the most part, very many court proceedings are a complete waste of time, unless there's an asset which is worth pursuing.
Yes.
Why bother?
I think this is another, because we're going to be here 2 hours if we start talking about this. I mean, the idea is that at some point technology should come into play into diagnosing the merits of a case very early on. I think there will be a technology in due course trying to figure out a singular technology to figure out whether there are assets to enforce the judgments against before we place burden on a court system, place burden on the client for their costs. So, you almost like a certificate. I'm not saying this. We're just brainstorming as we used to do in our in our sessions. But that's another session. We could talk about that. We've talked about before the case AI. We talked about technology. We talked about all this. Almost like a ambition for the legal industry. We hope we have this. We hope we can build this, because it would clear the pain points that we have in not just for us, but for clients as well. Cost, efficiency, and pacing, the swiftness of getting to the solution, and not just paper victory, a Pyrrhic victory.
It is a Pyrrhic victory. I mean, what we're talking about, what we've largely discussed, is what applies to what you might call sort of private practice outside the big firms.
Yes, correct.
They're dealing with in an arena where commercial law and competition law and so on have a different significance, don't they? The weight of the cases and the money and all those.
Yes, correct.
But nonetheless, the vast majority of the population should have access to all the things that we'd be talking about.
Correct.
And currently, I wouldn't say that they do, actually.
No.
I really don't think they do. And so...
Well, that's food for thought for the next episode. I think we will segue there, and we will pause for a moment and use that as something to think about. If you're watching this, it is highly likely that the next episode we'll talk about that. Before we go, I'd like to. I'm very, very proud to recommend and to present 2 books made by our very own Phil Willens, authored by Mr. Phil Willens. We've got Shapeshifter, which was published last year, Phil.
Yes.
And recently published, yesterday or today, Up in Front of the Beak, again by Mr. Phil Willens. Phil, do you want to talk briefly about those two books, just as a trailer.
Just very briefly. I mean, the Shapeshifter is really an odyssey. It's a young man, teenager, from a very poor background, and it traces his journey through life, through various stages where he, chameleon-like, undergoes various changes of identity. It's not a legal novel. The Up Before the Beak is the beak in Victorian times used to be the way you describe a magistrate. So up until the 1950s, if someone said they're in front of the beak, they'd be in front of the magistrate. And so in this case, that's exactly what that's intended to be. But there are carrots in it, and so it was simply a question about a little bit of wordplay. But it's a story about an old-fashioned type of solicitor, broadly modelled on one I know quite well. and his assistant, who was actually a young Indian woman born in this country, so that it represents a transition really from the old world to the new. And it's just a fairly light-hearted romp through their adventures together.
That's very, very good. Well, Phil, do you want to tell them where can they get those two books if they wish to get a copy?
They can get them from the publisher, who's... I need to have a look.
We will put a link on with this video somewhere there.
They can put it for the publisher.
But the publisher will sign
Chesterfield. That's right. He has copies in Chesterfield, and then all they do is I wanted to ask you about this. They could apply to me directly.
Yes, but they can write. We will write. What we will do is we'll add an address, an appropriate address that I will confirm with Phil. It could be in the office, so it's fine if that's okay with you.
That actually would be okay.
Yeah. Brilliant. So you could write to the office if you'd like to. You could send us an email. If you'd like a copy, then we can arrange.
Simply charges and postage.
Yeah, we will arrange for all those. You could send a link for the payment method and all of that. But it'd be good. Very, very proud moment. I think 2 books in a year. It's amazing. And Phil, I just want to say this, and it's we just released the trailer, and I think a lot, especially those teammates that I told you about, and everyone that I invited to be a part of these open sessions, they've all been so positive, and they've all, we all felt the same privilege to be a beneficiary of all of these knowledge and all this inspired creative solutions that we call it.
Very nice of you to say so.
And I'm very, very grateful. I'd like to end this with thank you. And do support Phil's books now. 2 books. We'll put a link somewhere in with this video so you could access it. And it will always feature in our set. So you'll be reminded to get it. Phil, thank you very much. We'll end this episode now and see you everyone next time. Thank you.
Thanks very much.